Well, hold your horses. Maybe the Ninth Circuit didn't kill the jurisdiction of Judge Breyer in San Francisco. Maybe he, like any other federal judge, can provide oversight over Donald Trump's continued attack on California, his attack and assault on states' rights, and to declare that Donald Trump violated the Posse Comitatus Act because he continues to use the Marines on soil against American citizens. Maybe the Ninth Circuit's ruling last week did not divest this court, Judge Breyer, of jurisdiction. That's what we're going to get to the bottom of, because we got not one, but two new filings that came in as required by the judge, one from California, one from Donald Trump. I'm going to tell you what the arguments are, why I think at the end of the day, Donald Trump is going to lose and Judge Breyer is going to retain jurisdiction, at least as to the preliminary injunction phase, at least as to the Posse Comitatus Act, at least as to how long Donald Trump gets to federalize the National Guard after the emergency, the phony trumped up emergency he created, is long since passed. If the emergency is over, who gets to declare whether Donald Trump gets to continue to federalize the National Guard and try to embarrass Gavin Newsom and violate states' rights? I say a federal judge. Let's get to it here on Legal AF. Ninth Circuit Court of Appeals last week, 3-0, ruled in favor of Donald Trump, said that they have to give high deference, have to be highly deferential to the president in terms of when he decides to federalize and when he decides that he's got the right to federalize the National Guard under the 1903 Militia Act, also known as 10 U.S.C. 12406. So there's three grounds, three triggering events under 12406. There's a rebellion, and that's like a defined term from back in the old-timey times. And the judges, even the Ninth Circuit said there's no rebellion. Secondly, whether Donald Trump is having difficulty executing the laws with regular forces. That one's a little bit up in the air. They said we as a judges get to provide oversight to the president. So they rejected Donald Trump's fundamental argument, which is federal courts have no role in telling me as the president what I can and can't do under those powers. They said, no, we don't buy that. But we're going to be highly deferential to what you decide to do. And so they gave him a win there. What they didn't address, and this is important for the new filings with the trial court judge, they didn't address whether how long Trump can continue to exercise power over the National Guard once that emergency, that exigent circumstance that was the basis for their decision is long since gone. Who gets to make that decision? Should be a federal court. And they did not address an issue that was not developed below by the trial judge, Judge Charles Breyer, which was whether Donald Trump violated the Posse Comitatus Act because he's using the military against U.S. citizens on domestic soil. And the fundamental requirements of an appeal is that it only address those things that were properly vetted and litigated below at the trial court level. Federal appellate court judges do not have jurisdiction over matters that were not addressed by a trial judge. And so Breyer never got to Posse Comitatus Act. He never got to how long of a period of time the takeover of the National Guard could take and other things related to the preliminary injunction. So California in its filing, and I have both here. Here's Trump's and then I have California's. California in its filing said, look, fundamentally, the Ninth Circuit may have granted a stay to block you, Judge Breyer, and to block your temporary restraining order. But they said they were not addressing the Posse Comitatus Act. You haven't addressed it either. So the lower court hasn't even addressed it. So the appellate court couldn't have stopped it. That's the first fundamental argument. Also, the court, because it didn't have a proper record in front of it, also did not address at the appellate level the duration of how long this occupation by federal troops can last. That's still for you, trial court. And other issues that could come from new evidence and new documents and new bases for the either a new temporary restraining order or a new preliminary injunction. See, that happens in cases all the time. There's one issue, it goes up on appeal, it gets resolved, but then new facts come up to support a whole nother motion for injunction. And an appellate court can't stop that and can't stay that. There's a reason why, and I've been doing appellate law for a long time also. I think my first appellate argument was I was literally 1 year out of law school. Appellate courts don't like to take cases before they're ripe for appeal. 90% of appeals or more happen after a final judgment in a case, either by jury verdict, by a judge, by summary judgment, by some final dismissal of the case. Somebody takes the appeal. That's a normal appeal. Then there's interlocutory appeals, which happen during the course of a case before final judgment. And they're disfavored. Appellate courts don't like them. Although you wouldn't know that, by the way, all these appellate courts are taking these temporary restraining order and preliminary injunction appeals by Donald Trump on an emergency basis. But generally, as I was taught in law school, they don't like that. And within temporary restraining orders and preliminary injunctions, they wait until the preliminary injunction because a temporary restraining order is pretty ephemeral. It's ethereal. It lasts a very short amount of time. But they didn't wait here. They ran in on a temporary restraining order on a limited record. And therefore, you're sort of boxed in. That would be the argument. That's the argument of California. You could have waited till preliminary injunction. You could have waited till later in the case, but you ran in on an incomplete record in an incomplete set of briefing. And now when facts change, the trial judge gets to fix it. That's the argument. The argument I'm seeing in Trump's papers, which, by the way, were bizarre. Not only bizarre because they were only 5 pages long, they seem to end in mid-sentence. Again, another quality control problem. I'm like, where's the concluding paragraph? That's the way they're ending their brief. It was very bizarre. But and it wasn't because they ran out of page limit. There was no page limit. Their fundamental argument is California is going to lose on the preliminary injunction no matter what the new evidence is because of the way the Ninth Circuit gave high deference to the president and found that there existed a exigent circumstance, in this case, the inability of Trump to execute the laws that will defeat any future findings and conclusions by the trial court judge. I don't agree with that. I think that's totally wrong. New evidence can always be presented to a trial judge that could change anybody's mind up to the appellate court. But their other argument is more academic. It's that the Posse Comitatus Act, which they acknowledge exists and makes it illegal and a crime for anyone to use the military on domestic soil unless there's an act of Congress that authorizes it. Their argument is that the 1903 Militia Act, which we know as 10 U.S.C. 12406 statute, is an act of Congress that allows for the Marines and others to be used on domestic soil. So there's nothing to see here. I don't see the 1903 Militia Act that way. It doesn't reference the Posse Comitatus Act or statute, and no court has ever interpreted that way. So I think we're up for a fight. This issue is, I think, here's what's should play out. Breyer, after reading these two briefs, is going to find that he has jurisdiction to continue in the case. He's going to call the parties in for briefing. He's going to grant California's request for additional discovery on the issue of the Posse Comitatus Act and whether there's new facts to support the other argument, which is the exigent circumstances or emergency has passed. Therefore, Donald Trump and the federal troops should get out of California. I think he's going to grant that. They're going to brief it. Trump's going to object. And then the loser is going to go back to the Ninth Circuit. The loser of that's going to try to go to the U.S. Supreme Court with an emergency application. And then we're up and running. I just don't think Gavin Newsom has a choice but to continue to fight. And he's doing it the right way. First, go back to the trial court judge. Convince the trial court judge they have jurisdiction. Then, when you're done with that, then you need to go to the United States Supreme Court to try to reverse the Ninth Circuit's original opinion on this highly deferential standard. Because it's terrible law, especially for states and states' rights. Now, they can do it one of two ways. They can actually do it both ways. They can ask the full Ninth Circuit, which is you go to 29 judges of the Ninth Circuit, and you try to get a majority, so 15, to rule in your favor, that there should be rehearing in front of the entirety of the Ninth Circuit instead of the 3-judge panel. You then have, if they agree on a majority, they set up a panel, randomly selected chief judge, plus 10 others. Some of the 10 can come from the 3 that already voted against, but they'll get 11. And then you need a majority of the 11. He'll either try that, Gavin Newsom, or he'll go to the United States Supreme Court. He just can't leave this on the books. Well, we got the 2 briefs in. I'll post them on the Substack. so you can read them for Legal AF. And I'll report immediately after I hear what Judge Breyer does right here on Legal AF. While you're here, hit the subscribe button, come over to Legal AF Substack, subscribe to that. It's all for free, by the way. And then, of course, we got Legal AF, the podcast, Wednesdays and Saturdays at 8 p.m. Eastern Time on the Midas Touch Network. And I got a new podcast that I host. It's on Tuesday nights at 8 p.m. Eastern Time on the Midas Touch Network. It's called The Intersection. Join me 8 p.m. Eastern Time on Midas Touch if you like this kind of analysis and work for The Intersection. And we also need some audio downloads. So pick it up on your podcast. Just go put in The Intersection. You'll see my photo. That's me. Download that and rate and review that. We need a 5-star reviews for The Intersection. So until my next report, I'm Michael Popok. Can't get your fill of Legal AF? Me neither. That's why we formed the Legal AF Substack. Every time we mention something in a hot take, whether it's a court filing or a oral argument, come over to the Substack. You'll find the court filing and the oral argument there, including a daily roundup that I do called, wait for it, Morning AF. What else? All the other contributors from Legal AF are there as well. We got some new reporting. We got interviews. We got ad-free versions of the podcast and hot takes. Where? Legal AF on Substack. Come over now to free subscribe.